they don't. So as far as I know, it's a good statute, and so I have to do it.
And then the last follow-up on this one was the people feel like their right to speak in Bonner County is being taken away from them systematically, and we're gonna see some of that as we go to this next agenda. How does that not make it, I know, because your scope is a lot larger than coming to this meeting, and that's hard to compare, criminal law to open meeting violation. But for this group of people, public comment and being able to address their elected officials and to be heard without fear of retribution is the primary concern. It isn't the criminal aspect, because you're juggling both. So how do we pull our community back to the forefront of being able to communicate? And how should they communicate with you so that it's not cumbersome, but that they get the benefit of you forwarding their message on?
Okay, so 1 minute caveat, if I can do it.
Okay.
I fully understand what you're saying, and I agree that is what all the people, no matter which side. I mean, and I loosely call people Asia's side and Luke's side.
Don't worry, it doesn't matter. People that say they don't like
camps,
chats are in this room,
but
so we're good.
You know who I'm talking about, and you know what I mean by that. You could be in both camps. I don't know, but both sides care about what's going on with the county in this building, and I totally get that, and I'm not discounting it. I want to remind you that 90% of my job is the enforcement of criminal laws in this county, and I am by far the most experienced trial attorney, maybe in North Idaho at this point, clearly in Bonner County. My job is to prosecute murderers and rapists, and I do a pretty good job at that. And I hope you don't lose track of that, because you could get a prosecutor that perhaps, might be politically more like you on whichever side you are, but would not know what they're doing in the courtroom. And that is not necessarily a great thing. And you could have me as a defense attorney whooping them pretty badly. We don't want to really see that. So, but I do understand it clearly is part of my job, the civil representation. I do take it seriously. I think that Mr. Wilson is very, very capable. And he and I talk about things on a daily basis, every day, 7 days a week. We are talking with each other about things. It's difficult for us because we represent the county, the entity, through its constituents. And what that means is not constituents like you. It means the constituents within our own entity or organization, which includes Asia, Luke, Steve, Rose, Wheeler, all the elected officials, and then down to the department heads and employees. So that's not always the easiest thing to do, especially in this situation where the elected officials do not get along well at all together, obviously. So it becomes difficult to try to render advice to them while at the same time taking complaints in from the public. But at the end of the day, we are not supervisors of any of the other elected officials. We provide them legal advice. They then choose whether to listen or not to that legal advice. The only thing I guess that, and again, if you're from either side, maybe ask those people what's been bad legal advice that Marshall's given, and see if they can answer you.
So a question in line with that is, does the chair have the right to choose who is allowed to give a public comment? And so there's been a few weeks where people have signed up for public comment and their names have been taken off from public comment. And when that occurs, what's the recourse for the individuals not being allowed to speak? And then there's a piggyback one, because a form has just been created where there's a statement where you have to give an email address and you have to say what it is that you want to speak about. Does Bonner County have the right to impose that? We've usually just said, sign up with your name, confirm that you're a Bonner County resident, but we haven't said you must give us your email. You have to tell us before 9 a.m. that you have a question, and you have to tell us the topic of your question. Do the public have to comply with that in order to give a public comment?
Okay, so I've advised the board back in March of this past year, and it's a pretty thorough opinion. And it basically, I think, is pretty strong on the law. And what it says is there's a whole bunch of different laws coming together. We have Bonner County Ordinance, which is law. We have Idaho state statute, and then we have federal constitution. And of course, as a lawyer, the federal constitution trumps all, right? And Idaho state constitution.
So when you overlap these things, there are issues when you go after content of speech. And that's the problem when you pick and choose.
So one of the other questions was, please provide a definition for the term Bonner County business, and this is arising out of a decision of the board to decide who has business in Bonner County or not.
Okay,
Sorry about the voice this morning.
You guys make him afraid.
You do. I'm very nervous, as you can tell. Just sitting next to Asia makes me nervous.
Get in line.
So just going back a little bit to the last question, and if I remember, I'll address that one too. But so we think that, and we've given this advice publicly to the board, so there's no attorney-client privilege at this point, and it's just generalized legal advice, which is different. There's a different, okay, so some people, attorney-client, that's a little weird. It's a lot easier when you have your own private attorneys. We all kind of get what that is, right? Your communications with your private attorney, they have to keep that confidential unless they are ordered by a court or for some other legal process. As legal advisors to the commissioners, I am not Asia's private attorney. I'm not Steve's private attorney, Luke's private attorney. We represent the entity. And so most of the communications that we have with our clients are actually open. And you've gotten to see that with the public records requests that have come in. So you've seen a lot of emails that are from me to the elected officials. We haven't said those are attorney-client privilege because they're not really confidential communications. Now, when we're talking about a specific lawsuit, like an executive session, you're not going to get those because that's where I'm telling the commissioners or the sheriff or both of them what our vulnerabilities are. So that's different than just generalized legal advice. And so what we're talking about here is basically generalized legal advice. And so it's our opinion that probably under Idaho code, you might be able to remove all public comment to basically encapsulate the business. I'm not saying it's a good idea. I'm not for it. I'm totally against it. But it's my job to say what I think is legal or not whether I think it's a good idea. I think it's a bad idea. And we've told the commissioners that. But you might be able to do it. The problem becomes if you let any public comment in, then you're looking like you're going after content. And that's where you have the real difficulties under the First Amendment doctrine. And you see some cases across the United States, not just Ninth Circuit. You see it in other circuits. You saw, if any of you watch Fox News or look at it, there's a commissioner that got arrested basically for First Amendment things in Ohio and cleaned up against her own county. Not going to happen here, right?
We don't have any money to clean up, so.
We don't have any money. That is a very true statement.
Definition
Yes,
of
ma'am.
business, no, put your hand down.
Oh,
Definition of business. On this chat, I advance warned everybody, send questions so we can get through as much as possible, and then we'll do questions after that. Because I wanted to make sure we got through stuff.
I don't recognize the press.
It's not a form. Question,
Okay, business.
definition of business. That question was emailed to me, so, and that person's here and they deserve their answer.
Absolutely. So business is not defined, as you probably already know. It's not defined in our county ordinance. It's not defined in state law. I think business is a broad term, meaning not just what the commissioners do, but what the other employees do and elected officials is also business. So I guess the question is probably how much can other commissioners, if you have a majority of the board, how much can they limit, let's say, what Asia can say? Because I think that's what we're really kind of
That's your
getting
next
at.
one after that.
Okay, and that is not a easily definable question. Clearly, the majority of the board can amend agendas. There's no question about that. But what happens when you get so far that you're essentially silencing an elected official? And I think that's where you run into some problems. And that may or may not be where we are at this point. So we have cautioned the board about that we struggle. And that goes back to the Ohio, what we saw. And again, we're not in whatever district Ohio is in, but that's a scary case for cities and counties across this country that, even perhaps members of their own ruling board or executive board have causes of action against the entity itself. So I would encourage the majority of the board to allow, clearly, any of the so it's even more than just a board member. So we have thought about this a little bit. So what if you had two board members that really don't like another elected official? Let's say me. And they decide, because it's their agenda and they do the business, that we're just not going to let Marshall put on any of his claims to the county. We're not going to let him buy a desk because we hate the guy and we think we can do this because we control the agenda. And if we don't pass his claims, it's not getting paid. Okay, I think, well, that is not addressed under statute. There is sufficient case law that says that if you stop an elected official from doing her or his duties, you've gone too far. And there's a case called Allied Bail Bonds out of Kootenai County that is kind of a seminal case, but there's other cases as well that address that, going way back to, frankly, the turn of the century. And I don't mean 2000, back to 1900s, that deal with this. There's only one, there's a multitude of cases. Anytime elected officials get into a battle with their commissioners, there are a multitude of cases, again, going back 120 years. There's one case where the Board of Commissioners won. It was in the 30s, I think, and involved buying police cars. All of the other cases, the other elected officials won every single time, up and through Allied Bail Bonds. And so it's not beneficial when boards of commissioners try to stop other elected officials from doing their job. And that includes probably the third member of the board. So it's a dance. There's not a bright line answer with that. It's like with anything else. It's moderation is probably the key. They do have some rights to stifle, let's say Asia. They have some rights to stifle her through agenda, but not all the way. Did I answer that?
No, because since you said not all the way, I'd like to know how I get my items on the agenda.
No, I think we've given that legal advice clearly, that any of the three commissioners have the right to put agenda items on the agenda. The question then, does the majority of the board get to amend that agenda? And a lot of times I think the answer is yes, they can.
What the concern is that comes out of what's happening is it's a systematically removing of an elected person from representing, and they're duly elected. And how do you balance that in a community when two people choose to do something that increases the risk to Bonner County? Because part of what I hear you saying is, in order to get a real remedy, somebody has to sue based on the decisions that are being made, so that forces the correction. And should Bonner County accept that type of litigation just for politics?
That unfortunately is the way in our society things are. If you can't come together and figure it out, you're left with your only recourse is through the courts, and that is very costly. And it's one of the things too, I think, that people that haven't been in the court system think is you can ask judges for opinions, right? Because it kind of makes sense that you can do that. You can't do that. There's kind of an archaic provision for advisory opinions. They won't do it. So a lot of times you have good ideas. And we've seen this in the past where we've had even all three board members before the current board. We've had all three board members on the same page, and they've wanted a judge to give us a decision. Like even, let's say the festival, right? They say, we think that guns should be allowed. We think that gun rights, Second Amendment rights, and even rights under the Idaho Constitution trump property rights. Okay, that's a really good argument. And we think a judge should make this decision, and they will make this decision. We'll just present it to the judge and we'll get an answer. Unfortunately, it's not the way it works at all. It just doesn't. The best we can do is ask the prosecuting attorney and or the attorney general for legal advice. But those are just opinions. So the board is not, they don't have to listen to the attorney general, and they don't have to listen to me.
And so the last topic that we have in advance is West Bonner County School District. What is the relationship from the prosecutor's office to that school district? There's some issues and concerns within the community. And if you answer that and combine it with the question that you received, then we can turn time over to people to ask. But that's a question in Southwest Bonner County is the school district. And I think a lot of people think that you can go in and stop or fix or change something.
Yeah, so no, I can only do what's in my jurisdiction to do, and my jurisdiction is obviously a lot different than other county officials. You know, the commissioners have their jurisdiction, I have my jurisdiction, the sheriff his, mine goes technically, my jurisdiction is statewide, but in reality, of course, that's not, I don't go down into Kootenai County very often and mess with what they're doing. That just isn't proper. So it's basically countywide. That includes West Bonner County School District. If there's allegations of open meetings violations, which there have been, if there's allegations of improper misuse of county funds, those all fall under my office. And so we have been looking at some of those issues and we'll continue to look at them. With open meetings violations, we basically do those ourselves. With issues of misuse of funds, that's something where we're going to need law enforcement to do it. I mean, we don't, our job is not to investigate crimes by and large. Very rarely do we do that. Again, open meetings violations are not crimes. But when you're talking about crimes, we need law enforcement officers, cops to do that for us. And so basically what we would do is we intake those type accusations, and then we funnel it out to the appropriate law enforcement agency, which in that case is very likely going to be the Bonner County Sheriff's Office. And so likely in the way they do things is they would take an initial report, a lot of times by just a deputy, and then that would very, very likely go to the detectives division. And my office works very closely with the detectives of Bonner County and also Sandpoint and ISP, Idaho State Police.
Let's use microphone, Marie. That's what I'm saying.
Okay. Good morning.
Good morning.
My question goes to public comment before a county ordinance is passed, and whether or not the people have a right to weigh in on that before the ordinance is passed.
She meant to say, does the community have a right to weigh in on it before? Is there a process for
Yes.
it coming into place?
She knows.
I understand what you're saying, Sherry. So the only time when it's mandated is our public hearings. And very rarely are the ordinances that are passed part of public hearings. Sometimes, but not that often. So yes and no, I guess, would be my answer to that. And again, what I'm saying is what is legally required, not what I think personally should be. My opinion, and again, this is not a legal opinion. It's just someone who's been doing this for a long time, a lot longer, frankly, than basically all the other elected officials, but is sometimes it's good to just take dissent. You know, there's a lot of people in this room that don't think I'm doing a good job, that don't like me. Sometimes it's good to just listen to it and hear what they have to say. You don't have to agree with them, but it's better than trying to stifle that comment.
You ever had such a contentious board?
No.
I did
No,
not
I've
give you
been
the mic.
through,
Move on, move on.
I wanted to add on that because I know where some of the other questions come is, what is the recourse of the community when the rules for passing thing changes? And so, for example, we historically on this board see HR policies went through workshop. Then we come to pass and they say no. Then they say they want a workshop. We do a workshop and it comes to pass and they say no. But we hear a verbal from the chair, we must put these things through workshops. Unless it's the thing that they want to pass. And that inconsistency causes division within the community because it feels like you're stifling, again, the communication that you don't want to hear. And that is expanding in the minds greater than just public comment. It's the input, and systematically, we've been doing that almost every Tuesday. And when you come today knowing that public comment has a form that's not even out before 9 o'clock for anybody to fill out with all of their demographic information, how do you balance what the community can do to be heard here? Because what we're creating is the storm that has people with an obligation to stand up for their right to speak in a reasonable manner, and we're not allowing that, and it's creating the dysfunction that people are reporting about.
they're clearly, we've had some folks that have been highly critical of me, for instance, in the past. And basically, it's probably best to let the people say what they want to say and listen. It doesn't mean you have to agree with them. And I think that part of the problem, and again, this is just my personal opinion, it's not a legal opinion, but I think the board, frankly, has brought on some of its own issues, and maybe if something's not working, try something different. I don't always make the right decisions. I mean, I know that I make mistakes, but you got to learn from your mistakes. And I understand Asia, for instance, Asia's highly intelligent and she agitates a little bit. I get that.
No.
And I understand that, but don't let her, you know what I mean? And you have to sometimes pivot and do something different when you're not winning, I guess. That's just my opinion.
Well, since you use the word agitate, I'll say, what do you do to get the people to follow the rules that they impose themselves? Because it's one way to say agitate, but it's also another way to say there is no recourse. And that's kind of what the problem in our issue is no one would have imagined a board that does this. And so, because I can argue, well, wait, I don't get anything on this agenda. So what do? I can't give a public comment. Let me do Brian Domke and then you, so, because his hand was up first. Ryan, can you unmute yourself?
Yes, thank you, Asia. Thank you for the opportunity to ask a question. And if you have reviewed the proposed amendment addition to county ordinance that is on today's Bonner County business meeting agenda, do you find that to be both constitutional and enforceable?
So I understand what you're asking. I know that Mr. Wilson has given legal advice to the board on that particular issue, and he did not. I can tell you this. I don't know if that has been made public, that legal advice, so I can't address that directly. But I can say that he did
I'll
not.
leak my information then. Bill
With
Wilson
pride, you
did.
can.
Bill Wilson did not recommend using what's being presented. He also stated with respect to enacting laws from standpoint that wasn't reasonable with respect to public comment. So it's moving forward, and I do believe that it's moving forward with the request for a vote with an opinion that says the concern is that it infringes on public or the right to free speech. That's what the concern that was given. So, and I don't think it's fair to ask Marshall that question because he didn't write it. But Brian, I can email you that document so that you can see it in advance of the 9 a.m. meeting.
I would greatly appreciate that information, and thank you for that response. It seemed suspect that there were comments that this was written by another attorney, and that attorney is no longer available. But I didn't see any indication in the board packet about the legal opinion from your office. So thank you.
Good morning. Thanks for coming. And thank you, Commissioner Williams, for organizing these community chats. I think they're very helpful.
I feel like my dog right now.
Let's see if it's the microphone.
Two of the questions that I was going to ask the commissioners, if I was even allowed to speak during public comment, were about two issues that seemingly are dividing the community or being used to divide the community. And you addressed one of them. What's the definition of business? Seems really kind of odd to me that that's even a question. You may not be able to answer this, but I'd like to just kind of throw it out to you. What's the definition of community organizing? That's something that's been introduced to the public discourse. And I think that it's ludicrous. And I think it was deliberately picked to evoke a particular politician and to be some type of slur. Do you consider yourself a community organizer for participating in this type of public engagement?
I don't even know what that means, I'll be honest with you, the community, or I know that there was, that's what Obama, and trust me, I can read between the lines. I can't really address that. I don't have any issues. I'll tell you, and maybe this year someone's gonna run against me. It seems like that's a possibility, but the last time that happened was 2012. And I remember going to the forums, the public forums, and you'd have the same groups of people that would be out there and they would ask you the same questions, and they were all loaded questions, every one of them. And I don't see, and again, this is from both sides. I don't see those questions from this group in both sides as being those type of just, there are some gotcha questions, of course, but I see a lot of people that honestly just want answers. And that goes to Luke's, what I'll call Luke's crowd too. And that they're
Aren't there
asking,
three crowds? Because there's three commissioners.
I don't know if they're Steve and Luke's or just Luke's. Again, I'm not putting in, it just seems it's in order to, we know who we're talking about, right? But even the people who don't like me and don't like Asia and like Luke, a lot of their questions are very legitimate. And, some of them I'm able to answer. And I think that the group that likes Asia, ask legitimate questions too. So I don't think it's people that are just trying to do the gotcha thing all the time. I think they want answers, and I try to answer, and I would hope, I can't compel the board to do that, but I think it's a good idea, and I think that their meetings will go smoother if they just tried to answer some of these things as opposed to pushing everything off and saying you don't get to comment. That's just my opinion on that.
Hi, Louis, first of all, thank you for coming today. Appreciate it. Brave of you. I wanted to make sure that I understood what you were saying about the Open Public Meetings Act. So did you say that in your legal opinion that that the commissioners do not have to allow the people to speak at the business meeting?
So Idaho state law says that they don't have to. There's some intricacies with that, how that intertwines with federal constitutional law. We have said that it is our opinion to be conservative. And in this case, conservative is to allow public comment because of the First Amendment concerns. The other issue is their own ordinance, which they didn't pass. It was passed years ago, but it talks about public comment quite a bit. It gives the authority to the chair to determine how public comment goes. There's no question about that. But because they're essentially with their own ordinance, they're inviting it. So the legal advice, which has been made public that we've given them, is if you really want to cut off all public opinion, which we're not advocating for, we think it's a mistake. But if that's what they want to do, they probably should amend that ordinance. And so to change it so that it's very clear that in Bonner County, we're going to run business meetings without having any public comment, except for those hearings where it is mandated, like public hearings where you have to allow the public to speak.
Well, it seems to me then that the state statute then is unconstitutional because
There's an argument for that.
yeah, because we have the right per First Amendment to redress grievances with our government, and when they are spending our money, that business meeting is our business.
Right. I understand what you're saying. That's part of our legal advice is, again, the state statute kind of contradicts some of the First Amendment jurisprudence that we've seen through the Ninth Circuit and other circuits of the United States. Now, there isn't a court decision from the Idaho State Supreme Court saying it's unconstitutional. So something's not unconstitutional until the court says it's unconstitutional.
Right. So is our only remedy then to take it to court?
Yeah, and it's very difficult to do that
Why?
because you have to have standing. And I'll just, and I'm not,
How would I have standing?
well, that you have to be an aggrieved party, and I'm not, I don't want to keep bringing up things that have been tough to have happened to us, but you look at the festival case, not only did Bonner County not have standing, but they were even questioning whether or not people who had actually been kicked out of the festival had standing. And not that there's an analogy to that case, but it's hard to have courts try to decide things as little as they possibly can, and they try to answer as few questions as they can to reach a resolution. And that's just their mandate, what they're supposed to do. So the fact that you think a law is potentially unconstitutional, there are prerequisites to get into that court, and one of which is you have to have standing as a person and aggrieved party to challenge that law.
Wouldn't any citizen of the United States have standing because we have?
I'm gonna
First
pause you
Amendment
for a
rights?
second, please. Luke, can I ask you guys to step out if you want to have a sidebar conversation? The mic can pick it up.
I don't know if any person would have standing or not. I'm not sure, to be honest with you. It does seem that way. I don't go through all the Attorney General opinions. I don't think the Attorney General's ever given an opinion on this either. And so, I mean, that's something that a Board of Commissioners or one of the state legislatures could ask the Attorney General and get their opinion. And again, the Attorney General's opinion is just an opinion, but I've never not followed one of their opinions. I would encourage people to follow them.
I
Thank you.
think this becomes a bigger issue than just Bonner County, because there are people across the country that are watching the struggle of the public to participate in local government. And we do have rules that say the people need to be able to meaningfully participate in what we're doing. And so that is beyond the ordinance that's up for review and change. And so who would be the best candidate? There's the option of going to your legislature, but the question for the people in this room is, how do I get to speak at the meeting that comes up at 9 a.m.? Because it's not just, I could argue that the Attorney General argument of meaningful participation means that they should be able to participate in the business, not just come and visit while we do the business of the county. And that is causing a lot of interest in the country and in our particular situation.
Yeah.
And I could argue that my question follow-up could be, does removing a sitting commissioner create standing to ask that to be readdressed?
You know,
I know that was an impromptu one, but when she said it,
well, I mean, you get like Doug, I'm gonna pick on Doug. Doug always asks about claims, right? About what the claims batch. And I think that that's been very fruitful throughout the years because, people are interested in what their money is being spent on. And so I personally don't view the public's questions as all being, going back to what I was talking about before, as gotcha type things. I think that a lot of them are very informative and they're actually asking things that they want answered. So they're legitimate questions. But again, it's not a legal opinion. It's just my personal opinion that I think meetings would run better that way.
yeah. Mr. Lady's hand is up online. Do you want to unmute yourself?
Yes, thank you. Prosecutor Marshall, would you address your inconsistencies in prosecution? 3 cases, for example, would be Deputy Galen lying to state investigators in the Craig Johnson case, the golf cart crash that killed a Spokane deputy, and Sheriff Wheeler in the Scheinmeister case. Can you address those inconsistencies, why you chose not to prosecute?
So the Craig Johnson case, I'm obviously very familiar with that. We have a memorandum of understanding throughout law enforcement in the 1st district. They're similar in other districts, judicial districts in the state of Idaho. And basically, when we have a critical incident, which is normally it's an officer involved shooting, we have a different prosecutor come in and review those for criminal charges against the police officers. So if the suspect or the person who was shot lives and there's criminal charges against that person, the prosecutor in that county prosecutes the person. Like for instance, in Blanchard, we had a horrible police shooting where the suspect lived and I prosecuted him. But additionally, we have to look at the actions of the police officers involved. It's not proper for the prosecutor in that particular county to do. So we send that to a special prosecutor. In this case, I sent it to Barry McHugh, which typically I do the Kootenai County cases. He was the prosecuting attorney, he's now a district judge, did the Bonner County cases. So it was Prosecutor McHugh that actually made that decision not to prosecute any of the officers. And I've reviewed it. I mean, if you're asking me for my opinion, Mr. Lady, I think that Mr. McHugh made the right decision. And I think you know that what I think about it.
But it's a state, or it's an actual fact that Deputy Gaon lied to prosecutors, and that is a crime. So, I mean, you can look at the records and you can actually see that because they had to call him back for a second interview, yet nobody prosecuted him. But let's move on from that. There was the
Mr.
golf
Lady, I
cart
have to
crash
pause you
and the
because
Sheriff Wheeler
Mr. Lady,
incident.
Mr. Lady, can I
He's
ask?
not done answering my question.
Mr. Lady, can I pause for you? So it's 8:45 and you did ask him a question. I have to let Maureen ask the last question here.
You let other people talk longer, so I'd
And
like to have
Mr.
my
Lady, you're asking
question answered.
specific questions about court cases and that's not what we do in Commissioner Chat.
He just talked about the festival case on his own, so yes, it is
Mr.
what you
Lady,
do.
thank you for your question. We're just not asking that specific. That's a reach out to the
You're
prosecutor's
silencing me, I
office.
get it.
He gave you the explanation about how his cases go versus another
And
county.
just to follow up for one brief second, Mr. Lady, you know, if you think that one of the elected officials, the county elected officials has committed a crime, make that complaint to the Attorney General, not to me.
Thank you, Prosecutor Marshall. I wanted to go to the West Bonner County School District and miss appropriation of funds. And it's been at least 10 months since we had a call in and 3 different calls requesting the detective to give some sort of information. It has gone to the detective division. And since then, there's been a phase 1 forensic audit that shows many discrepancies, and yet it just seems stalled, no response.
So any
The
type of,
reason I'm interrupting this one is I sent you that request from the trustee, and since that's open, she requested that response of you. That again is a specific to a case, and that's not what the chat's to do. Amy had her hand up.
I can just like, I can not to, I agree with Asia 100%, but things of that nature take time. So it's not like a single incident. They take time for investigation. So I would just advise to be patient.
Okay, so you mentioned the AG. So the AG is a very frustrating entity for me because in all these meetings, somebody says, go to the AG, go to the AG. And guess what? The AG says, nope, it's you, Mr. Lewis Marshall. And then we forward our complaints on to you and we never get an answer. Sometimes I get an answer, but most of the time we're not getting the answers. And so again, you know, for months I was coming in and asking about the Darcy Smith case. We had the press release. I was on the understanding that you were going to forward that information onto her. And now it's been revitalized. So we have all these people coming into the business meetings and asking for answers. But from what I understand from the AG is this commissioning board can't give them answers. It has to come from you. So are you planning on giving us an update? Because the last time the AG had also said that they had not received anything from you either. So I feel like it's been kind of stalled out, like it's not moving forward, or if it can't move forward, if we could just have a simple statement from you saying, you know, it's lack of evidence, you know, this is, it's stalled out and we're just going to move forward from here and do the best we can.
Okay. All right. So a lot of questions there. I did provide it to the Attorney General. I know Commissioner Bradshaw was questioning that. And I provided him. I sent him the email that I did. So whenever, I can't remember when I told Steve I was going to do it, but I did it right after that. And this was months and months and months ago. Now the Attorney General right now. So remember, the Attorney General does a whole lot of things, like way more than my office does. They have lots of attorneys, but their criminal division is very small. And their two of their best people are totally tied up with the Koberger case in Moscow. They're helping Bill Thompson down in Latah County prosecute that case. So that is taking up a lot of their time. So I'm just talking about practicalities here in terms of manpower. They don't have a ton of people to deal with all this, and they're getting tons of complaints. We're one of 44 counties. They're getting tons of complaints from Bonner County alone. I don't think they're getting as many from other counties just because of the nature of what's going on. What I'm saying is that they're getting inundated on a bigger scale the same way we are on a smaller scale. So I can't speak for the Attorney General, but yes, that information was provided to them. I know I talked to Bill Wilson about potentially releasing the entire report without redactions. The problem is that it was a personnel investigation by and large, and there's a lot of county employees that gave interviews, and this would be subjecting county employees to potential retribution, things of that nature. And we just can't do that. I mean, it just would not be smart to do that in any way. I'm confident in the investigation that we did. I've never said that I think it was bad. I also never said it was a forensic audit. I didn't do a forensic audit. I had a person, because the allegation was misuse of funds, they had to go back and to look into the accounts and stuff. So I don't call that a forensic audit, but it was definitely a white collar. I mean, again, they were looking at all the different accounts.
So I'm gonna let Jennifer go real quick and then we'll close it.
So quick question, thank you for coming on executive session. And I understand personnel issues, law enforcement, all that is confidential, but there's one today, it's called PRR/technology, and there's no further information about it. How do we understand something like that? It doesn't sound like something that would be confidential.
A lot of times technology can be confidential. Because it will show, there's things, critical infrastructure, things of that nature that make sense. So I can't address that specifically. A couple of years ago, before the changeover, when Attorney General Waston was still around, it used to be all you had to do was say the code section, the specific code section to go into executive session. The Attorney General advised that it's more appropriate to give a little bit more factually based so that people kind of understand what you're talking about before you go into executive session. That's a hard place for governments, whether it be counties, cities, any other governmental body here in Idaho. How much information do you give without it being too much? And so that's a difficult line to find. So you may have a good argument there that maybe there should be a little bit more information. I don't know the particulars, so to answer that.
So as we round out, I know fair has been a constant question. Is there any interest or desire for the board and the attorney and sheriff to do a town hall and give a time for community to ask about what's going on?
I'm open to that, of course.
Because I know I asked you already before and you said you not usually, but you're open to it.
I absolutely am.
And so, because some of it is not very clear because
Right.
of redactions. But I want to close out our commissioner chat. I see a lot of people here that have not come to chat before. I hope that you found it a valuable resource. Our next chat guest is going to be Army Corps of Engineers. They're going to go over our wetlands and how they do policies and how they do permits. And so that's a good one. I am asking them to come back through on the 20th. We will have Region 1 Board of Behavioral Health will participate. We had some requests from community members to bring in some mental health providers in the community to participate with chat. I am going to I got a reference for a personal therapist who also wants to do a commissioner chat. I am working with Stone Ridge on their water issues, and I have reached out to Idaho Public Utilities Commission to also do a chat because some of us don't have wells, we're on community wells. And as we grow and develop, people are being put in front of that commission and they don't know how it operates versus what a developer can do. So stay tuned. I've got a lot of people coming. I personally see the increase in need to protect our right for free speech. That's indicative of just the depth of which people are participating in online. This isn't just for Bonner County. It is across the nation. People are watching how we are responding to having our voice stifled in this meeting. We have communicated in a respectful manner from people on any side, regardless of your political standing. And we can do that during all businesses and give our opinion to those that are making decisions about your day to day. So I thank you all for coming. Thank you to Lewis Marshall for taking the time. And we'll let technology can stop the stream on this and then we'll break. And then this room is where it's noticed for our commissioner meeting. So they're supposed to come down here. Give them 5 minutes to run.